you to introduce yourself in a little bit more detail, but Oliver Bethel from Google and Matthew Brovak from the CMA, from the Competition and Markets Authority, more specifically the Digital Markets Unit in the Competition and Markets Authority. We're going to have a lot of acronyms. Do you want to go first, just to give us a couple of sentences to introduce yourself, Matthew?
So thanks very much. My name is Matthew Brovak. As Tom said, I'm one of the directors in the Digital Markets Unit in the Competition and Markets Authority here in the UK. And as we'll discuss in a moment, we're in the process of preparing the new digital markets regime, which is expected to be introduced in the UK next year. And we can talk a little bit about that. Some of the work that I do includes working with other regulators. So in the UK, we have something called the DRCF, the Digital Regulation Cooperation Forum, where we work together with the ICO, with Ofcom, and the FCA, and also some of our international links, which I'm responsible for.
Oliver.
Hi everyone, my name is Oliver Bethel. I can see from my profile photo I've gone full Steve Jobs. I'm the lead of Google's competition department for EMEA. That's the region I cover. That responsibility includes our competitional matters and engagement, and that cuts across both our day-to-day cases with various regulators, but also more of a lean towards the policy work that sits around a lot of that enforcement work these days. And also now the sort of emerging field of competition ex-ante regulation, which is related but somewhat different in what it will involve for us. So your DMU, the Digital Markets Act, working with Matthew and his colleagues, and also the Digital Markets Act, which is the landmark piece of legislation coming out of Brussels.
Thank you. So what are we going to talk about today? So regulation is obviously everyone's favourite topic. So over the last 15 years, the big tech companies have grown, brought in amazing innovations, and grown their market power, and they now occupy really central positions in the world economy. Regulators have been starting to worry, probably started worrying about, 5 years ago or so, about this, and about the gatekeeping position that the large platforms, Google, Apple, Meta, Amazon in particular, and Microsoft as well, to some extent in some markets. They're starting to worry about the position they occupy and whether they hold kind of life or death power over smaller companies, whether they mean to or not. I'm sure they don't mean to most of the time. Can enter a market and push other people out of business, and can self-preference their own products. As everyone knows, a company will struggle to do well if it doesn't appear relatively near the top in the Google search results. Well, discuss anyway, because people might disagree, but if you're on the second page of the results, you're not going to get as many clicks. So where you are in the search results is obviously very important, and therefore Google, whether it wants to or not, has power over who appears on the first page of the search results. Regulators have been worrying about that, and competition policy has moved more into the political limelight in recent years. You have really across the world proposals for new regulations in the tech sector. In the EU, they have already passed the Digital Markets Act. In the UK, there's similar proposals going through Parliament that will be entering the report stage of the House of Commons on the 20th of November, I believe, and therefore may become law possibly something like spring next year. Australia has proposals. South Korea has an app stores law already in force. Germany already has a law in force that it's already enforcing, which regulates the big tech platforms. America, as many of you will have noticed, there's doing it a slightly different way, but there's big blockbuster cases. The DOJ, the Department of Justice, is taking on Google in Washington. The Federal Trade Commission is taking on Amazon in two very important cases in our world. So we, conferences over the last few years, we debated whether new regulations should be brought in for tech companies. Really, that debate's over because they have been brought in or are just about to be brought in. So we're going to talk about the next phase, really. what's this going to mean now that they come into force? Will it help smaller companies to grow? Will it even provide clarity to the big tech firms who are fighting these antitrust battles, these competition battles all over the world? Will it actually be welcome clarity that we'll all now know the rules of the road and we can get on with innovating products instead of talking to competition lawyers? Or will the new regulations dampen innovation, increase costs, and do all the bad things that people that don't like regulation think might happen? So that's my little intro. Sorry, that's probably longer than I should have done. Can I ask you first, Oliver? So the EU process is the furthest along. Can you give us a bit of a summary about where we are now in the process, what Google's doing to prepare for the regime, and maybe even what you think the EU's trying to achieve?
I'm happy to. So the Digital Markets Act is just past an important milestone moment in its process. That's the designation process, and this is where the Digital Markets Act identifies particular companies based on their size, essentially, the number of users they have, the number of business users they have, and identifies for those particular gatekeepers which of their services are the ones to which these new rules ought to attach. So it's not a piece of legislation that is enforceable against everyone. It focuses on gatekeepers and the gatekeepers' core platform services. Some of those gatekeepers and their core platform services will come as no surprise to you and map to some of Tom's introductory remarks. Google and Search, Apple and Safari and iOS as their platform, Amazon and the marketplace, Meta and the Facebook social network. So there are several of those that you would recognize, and the 22 or so conduct rules attached to those core platform services. A little wrinkle to the process is that some of those designations are, how can I put this politely, open to debate between the regulator and some of those companies. Google is not involved in those kinds of conversations. We have our list now. But there are some ongoing discussions with Microsoft, for example, as to whether Edge is a browser that ought to be subject to these rules. Some conversations with Apple in relation to iMessage. So that process will play out, I think, will finish in around February. And then the big date is March the 6th, 2024. That is compliance. That is D-Day. From that point forward, we all need to be in compliance. And so begins or continues, I suppose, our regulatory dialogue against the backdrop of potential enforcement if you fail to comply. So that's where we are in the timeline. All very exciting. It's going to be a busy Christmas, I think, for many of us. What the Commission is trying to achieve, fairness and contestability in the markets in which those core platform services are operating. That's the sort of most pithy version I can give you of what the goal is here. I think one sort of important observation of my own that I attach to that is that it's become clear to us in our discussions with the Commission, quite rightly in my view, that this is about establishing fair processes, a fair environment in which the gatekeepers are operating and that those who rely on the gatekeepers operate. It is not about redistributing shares amongst various people who operate on the platforms. It's about ensuring that these platforms are operating in a transparent, fair, contestable way. And the 22 rules or so all drive towards that type of process outcome. How we are preparing for this? Well, it has become it's been a fascinating process for me. You know, I think over the years I've worked on many competition cases at Google, and there are things within Google that I would like to have had on a more permanent footing that actually this new regulated environment give me the ability to establish within the company. I'll to give you a couple of examples. Access to engineers and product experts, the availability of behavioral scientists to come and engage directly on a regular basis with regulators. We are now staffed for that. It's an ongoing project, but we have invested a lot of time in doing that. We have a function that within the company called Choice Lab now, which anticipates that regulators want to talk to us in an evidence-based way about choice architecture. So we're now directing a lot of resource to those kinds of teams and processes within the company. Governance. We now think, it's relatively new for a company like Google to be thinking about how do we build out a distinct and independent compliance type function within the company that can talk in an informed and data-based way with the regulator. That's something new. That's something that we have built within the company. And the final observation I'll say about our preparedness for the new regulation is a sort of, let's say, an evolution in how we think about engagement with the regulator. We've very much tried to shift to a mindset now where we think about engineering for compliance. This is about now engaging with regulators, choosing amongst different potential development paths and finding compliance solutions in a very much in a product launch type of way. How do we test? How do we iterate? How do we talk about tests and iterations? And that is how we've sort of tried to prepare ourselves for this new regulatory environment.
Thank you. So Matthew, the UK has proposals aiming at similar objectives, but doing it in a slightly different way. Would you like to give us a summary of what's happening in the UK?
Sure. So, as we said in our sort of introductory remarks, there is a bill in front of Parliament going into the House of Lords process shortly. It's very similar in its overall goals to the European legislation, but different in the way that it gets there, in the sense that we're trying to look for something which doesn't necessarily have all of the rules kind of set out actually in the legislation, but actually is a bit more tailored, a bit more specific. So that has two impacts, I suppose. One is it means that, you know, unlike the very clear timetable that Ollie was able to set out in relation to the DMA, because those rules are there, there's a date, they happen, the ball under the UK legislation is very much in the regulator's court. The bill, if and when it passes, gives us the power to set rules, but then requires us to do an evidence-based piece of work, activity by activity and company by company, to actually establish where is the market power that may be causing concerns, what are those concerns, and then potentially put in place through consultation and discussion and enabling other parties to get involved in that process, something called conduct requirements, which is effectively specific rules about behavior of those firms. Now, it's fair to say that, you know, this is very specific to a relatively small subset of companies. So there are also quantitative rules in order to fall under this regime. Gatekeepers have to have either £1 billion of UK turnover or 25 billion global turnover. And in addition to those quantitative rules, we also have to, and apologies for the acronyms here, we have to work out whether or not those firms have got something called strategic market status. And in order to do that, and that's a qualitative test, we have to think about whether or not they have got significant and enduring market power. So that means, you know, they have something like dominance, something like market power, and that isn't going to change over the period of at least the next sort of 5 years, so it needs to be forward-looking. In addition to that, we have to think about whether or not they have got a strategic position in the market such that they actually either set the rules for other companies' interactions with their customers or each other, and also think about things like their size, their importance, etc. So, you know, there's quite a big job to do for that. We're preparing for that at the moment. We are ramping up. We have got a significant number of people now working inside the digital markets unit, something a little bit under 70 people right in the digital markets unit at the moment. But we're also working across the whole of the CMA. So we've got data scientists in our data team. We've obviously got lawyers and economists also who are contributing. And our expectation is that over time, when we get to fully staffed up, we'll probably have about 200 or so people in the UK working on that. Because, you know, to take up some of the points that Oliver made, you know, this is going to have to be a two-way conversation, and we're going to need to have the skills on both sides of the table in order to have a meaningful, evidence-based conversation about both what are the issues and then also, you know, what are the areas that we might need to address with these rules. In addition to conduct requirements, there's something else called PCIs, pro-competition interventions. Broadly speaking, you can think about conduct requirements as being how do we want the gatekeepers to behave in order to prevent harm from their position of market power. PCIs are really to get to the heart of that market power. How can we actually improve competition, in fundamentally? And so there's a different process for that, a slightly longer process for those sorts of interventions. These are powerful tools. We absolutely recognize that it gives, quite a lot of, these regulations are potentially quite far-reaching, and therefore we also need to be really careful about how we do it, because I think the important place to start here is sort of where this conference started. We are pro-digital markets. I think we have to start with the fact that actually these platforms have brought a huge amount of benefit to consumers, both in the UK and elsewhere, and we want to make sure that they can continue to do so. So we are very keen to ensure that innovation remains. We're very keen to make sure that we're not stifling new business models, new competitors. What we want is to improve the market such that actually small, medium, and large companies can all compete fairly.
Thank you. I think it's right, isn't it, that so in the EU, platforms are designated if they hit a certain threshold, and these set rules apply. Whereas in the UK, as you're explaining, really it's all up for grabs. It's asking really quite a lot of this regulator to, the regulator, even when the law is passed, has no power to do anything at all until it proves its case against each firm individually, writes a bespoke set of conduct requirements for each firm individually, and survives all the appeals that may or may not follow. So it's quite a, from my way of looking, it's quite a kind of humble way of doing it. It's quite a kind of, it's quite a careful way of doing it, I think. But it will change the dynamic in the sector, in the tech sector as a whole. Oliver, up to now, people have complained, there are competition authority reports about Google acting as a quasi-regulator over certain issues, where, and Apple and other firms, whereby Google's in a position where it's got to decide what breaches privacy law or doesn't, because it's got to run its platform. It can't get it's not choosing to be a regulator, it's just doing its job. But what Google says is okay and not okay under privacy law really has almost force of law, because if Google says you can't do business on Google if you do it this way, then that's almost a quasi-regulator. Moving into the next phase, how do you think the dynamic will change between Google and its customers, its advertisers, its competitors, and how do you kind of see it playing out?
So I think that we have both the blessing and the curse of having engaged in these kinds of discussions, these difficult balancing discussions for some time now. We've had a number of big notifiable mergers that we've had to talk to regulators about. We've had a number of conduct investigations. We've been involved in a number of market studies and investigations internationally in the UK. So I think we've operated across various different parts of this type of new environment in the past, and you see these things all come together now, which gives us some base of experience, I think, to think about how we're going to do things moving forward. I think that one of the ways in which things will perhaps change is, well, not change, but I think one of the features that we will perhaps develop more in the new environment will be the frequency and the nature of the data that will underpin the engagement with the regulator. So the days of carefully manicured, top-flight law firm briefs being the way that you talk and engage with the regulator are probably, they'll still exist in some circumstances, the more adversarial stuff, so don't worry. But I think alongside that, you're going to have more and more of a day-to-day kind of engagement with the regulator, where it's something removed from that kind of, and people like me and people like you, Tom, will probably we'll do some introductions and hand across to the technical experts. So I think you'll see more of that. Why? Well, because we're building, as Matthew's alluded to, this is in the UK, this is a no-fault regime, right? We're being encouraged to talk to the agency, have the agency express to us where are these activities, what are the types of conduct that they most want to pay attention to, and then it's on us to engage and to explain where there are difficult trade-offs, to help people understand how we are engaging in those kinds of trade-offs, what data underpins our decision-making. I think that's absolutely crucial. This is not about exchanging, slogans and themes and ideas. It's about the underlying data that's motivated our decisions. I feel confident in that, by the way, because I think Google does a good job of making many of the decisions that I see, and so it's an opportunity to be able to talk more about those to the agency. There are, of course, a lot of other people who are important in this debate, other stakeholders, for want of a better term. And that, I think, is also going to be an important part of this new regulated relationship. Every conversation, most conversations I now have with a regulator, whether it's in the UK or in Brussels or one of the other member states, the notion of who have you spoken to, what have they said, is becoming increasingly important. I think we move, and for me it will be a happy relief, to be frank, we move away from sort of triangulating our views all via the regulator. And I think the regulator will expect us to come, to explain who we've talked to be transparent and open about the nature of concerns, to be transparent and open about the nature of support for some of our ideas, because it does exist. And that will be, I think, a key feature of how we talk to the regulator. I'll end on this. I think one of the upsides to us at Google of providing the opportunities for that broader input and broader discussion of some of the consequential decisions that we're taking is that it will give the regulator the opportunity to identify what is the right form of disruption. Because as we continue to innovate, as we continue to launch products, as we continue to find efficiencies for our customers, be they business customer or otherwise, people will be disrupted. Some firms will not enjoy the experience of an innovation that takes away some intermediary layer where they've been able to provide, a little margin on top of the acquisition fee. So if we can be transparent as we move into those kinds of decisions, then it helps the regulator understand that not every complaint needs to necessarily result in intervention, and sometimes it will be a case that this is natural competition, natural disruption.
Slightly nightmare scenario would be tech firms having to go to a regulator to ask permission to innovate. That would, I don't think, serve the British economy very well. Hopefully, I think we're avoiding that. I mean, are you worried there'll be a flavour of that, and maybe even if it's not in the UK, but maybe in Brussels or Seoul or in India, where they also have proposals for tech regulations?
I mean, I personally don't view the DMU, the UK regime and the Brussels regime are very different, right? They sort of drive, they're talked of often in the same conferences and the same panels, but they are very different in their constructs. And the Digital Markets Act in Brussels calls out defined products. That's how your core platform service is identified. There is a defined thing, which is a virtual assistant. There is a defined thing, which is an online search engine, et cetera, et cetera, et cetera. And then it concretizes the conduct and, to some extent, the nature of the remedies. So there, the framework is that we have a set of rules that we need to comply with, and it feels more like that there's a risk of those kinds of engagements with the regulator will be around having not done that properly. So it will be now. There's also language within the DMA which talks about regulatory dialogue, talks about the opportunity to test your ideas with the regulator, but we need to see how some of those work out. In the UK, on the other hand, we do, I think, have more of a framework which allows us, as I say, in a no-fault environment, to come and talk about our experiments, to talk about how we will iterate, to take their feedback. So that feels to me more like a sort of the kind of skunk works type environment that we're quite familiar with. And there are many of our products that we have launched, and we already engage with various organizations, various stakeholders to give them a sense of what we're doing, and we're broadening that set of people So no, I don't feel. I mean, I do see differences between the two, but I don't feel. And I have more of an eye on Brussels at the moment than I do on the UK. But I don't think this is an environment where we will feel that we're going to ask for permission. It's more the beginning of a conversation.
Great. Matthew, we talked a little bit about the flexibility of the UK regime, and certainly the UK government in the King's speech this week was touting the flexibility of the DMU regime as compared to Europe. How do you think that will play out? I mean, you have some areas where things are more or less settled nowadays, and therefore they would seem more ripe for regulation. You have other areas where things really aren't settled, and that would be AI, for example, is a good example about that. How will the DMU think about using its flexibility and on established products and new products?
Yeah, so I think that it's a real advantage of the UK regime if we use it well. That's how I would think about it. So there's obviously trade-off between, let's call it legal certainty on one hand, at least you know what you've got to do and what you don't have to do, and flexibility on the other hand. Now, I hope that by having both, for instance, the quantitative and the qualitative requirements that we talked about before, that actually there is some certainty. And equally, I think that I think that we can establish that certainty about, we're not going to be going after absolutely everything, from day one. We're not going to be going after those things. We're going to have to prioritize. Now, the advantage is that when new issues like AI sort of come up, now it is true that under the EU regime, as I understand it, there is the possibility of amending the regime and adding things and changing things, but it's very hard and probably, not going to happen quickly. It is easier under the UK regime, which is effectively an enabling regime, which gives the opportunity to the CMA to look at those new things, but exactly as you said, subject to the regulator proving its case, demonstrating that there is actually an issue and that there is market power that needs to be dealt with. Now, we've recently launched a piece of work, or published a piece of work on AI and foundation models. I think we're pleased with it as a sort of first exploratory piece of work in this area, and we've announced that we're following that up with further discussions with industry about effectively 7 principles that we've put in that, about access, about different business models being a good thing, that we think that there should be both open and closed models, and we like diversity, and we like to see competition in these markets. And I think that that's the kind of approach that, that's a kind of an example of how we see the new regime working as well, which is be on the front foot with learning and understanding about the new issues and engaging with industry, be rather more reticent on immediately coming in with rules. So we recognize in that piece of work that there are positives and negatives, there are trade-offs, as Oliver said, and those things need to be balanced. And we've also, I think, said that there are scenarios. We've said, look, this could play out in this way, or it could play out in that way. We'd be more concerned if it goes in this direction. We'd be less concerned if it goes in this direction. I think that's the kind of thing that is incumbent upon us to be part of that discussion, and to set out those thoughts, but also to have enough humility to recognize we don't know exactly how the market or the technology is going to develop. No one does, and so we need to recognize that.
Yeah, I suppose you need all sides to be talking to you, don't you? Not just large firms. You need challenger tech firms to talk to you, and I suppose there's a responsibility actually there. I mean, smaller firms are going to have to live with the rules once they're written. So from my point of view, I think it's quite important that even relatively small firms kind of start getting in contact with the CMA. And currently there's a blank piece of paper waiting to be filled in. maybe not quite blank anymore, but anyways, it's, for the new content requirements, and even for the established products, the rules are still to be finalised. But AI, of course, we're at an earlier stage, and other things that will happen. But hopefully from now on, now the laws are in place, small, medium, and large tech companies will kind of get involved a bit more, I think. Should we talk about a specific example? Because even under the existing laws, there's a kind of prototype for the type of participative approach that I think that everyone's hoping will evolve. And that's the privacy sandbox case that Google was involved in. Would you like to tell us a little bit about that, Oliver?
So I'm happy to. So the privacy sandbox is the technological response to the fact that third-party cookies, the tracking technology for advertising across the open web, are going to go away. And how does one respond to that? Why is it something that the CMA and Google are talking about? Well, because if you remove that particular type of technology that lots of people rely on to generate advertising, how does that affect the market? It's going to be consequential for many players. Does it give an advantage to the big incumbents? Does it affect the non-partners of the big incumbents less than the partners of the big incumbents? A number of very valid competition questions that can be asked about that kind of significant change to the way that the market is going to be operating. And the privacy sandbox, I think, was an acknowledgement of the fact that, although it seemed somewhat unusual to me at the time that we'd be talking about something so prospective, but it was so clear that it was coming as an issue that we would need to deal with at Google. And it also was very clear to us that, for me personally at least, of the difficult trade-offs that we've had to deal with as a competition team within the company, this is light years ahead of anything else. It's so complicated, the nature of just the information gathering that you would need to do to be aware of, as aware as one ever could be, of all of the potential consequences and effects of what would happen in this space. So those kinds of difficult trade-offs, the fact that we knew that this decision was coming, that led Google to engage with the CMA very early in the process. And I think that both sides had a kind of candid and open conversation about the difficulties that would be involved, particularly if we both came to this at the moment of deprecation with a great impact and no one really having an understanding of what the alternatives were or where we could have gone, and just a huge amount of noise and uncertainty for the market manifesting, which would be a very difficult environment for us and for anyone to engage on this kind of stuff. So we started early. We stripped away the lawyers and the policy advisors as quickly as we could, and we brought our technical teams to engage with the CMA. That, on the regulator side, that quickly kind of became more of a multi-regulator engagement. I think you're going to see more and more of this, by the way, moving forward. This is very much the beginning of this kind of, we de-silo a lot of these types of conversations. Copyright bleeding into competition, bleeding into privacy. This was a good example of that, an early example, privacy sandbox, a privacy motivation for making the technological change. So the Information Commissioner's Office had to be involved, but also these potential competition law effects. So bringing those two regulators together, bringing Google into that conversation, opening the door to other stakeholders to contribute their views also by way of various published documents. We tried to create this environment where a team from Google and from the regulators, as I say, tried to wrestle with this very difficult problem. Some features of that which I'm proud of and I think have worked well, the amount of regulatory expertise that's built up, sort of technical expertise that's built up within the regulator. As Matthew says, I think now a lot of this work will require much more of that embedded institutional knowledge around how some of these technologies are operating. The investment by us into that process with the engineers and business people, to be frank, who've had to engage in that kind of conversation. So yeah, I think that's sort of, the key features for me, very sort of an uncertain, but uncertainty in the outcomes, but an awareness that there will be a difficult trade-off conversation coming, a desire to move into that quickly, to not find fault, but to try and get the right people together to conceive of solutions, and to start early iterating and experimenting on the types of implementations that will result in, hopefully, a fair trade-off between the privacy motivation and the competition concerns that were out there.
One of the joys of being a big tech company is you're looking at a global market, and there's a lot of opportunities to grow globally. Of course, this case was UK only, with a little old island off the coast of Europe deciding something. Isn't there a problem here where you're dealing with dozens of different regulators around the world potentially? Once you've agreed something with the UK authority, is there an element of trying to go off and sell it to other regulators because you don't want lots of similar but slightly different solutions across the world? I mean, how are you thinking about this patchwork effect?
Well, I think the patchwork of rules talking point is one that sometimes I think I hear big tech drop that out a bit too often. I think it's a fact of operating in a multi-jurisdictional way that you have to engage with different rules and different regulators. That's a fact of life. And it's not just competition, it's across all different types of rules. So we have to be open-minded about that, and the fact that someone else in a different jurisdiction wants to look at a particular issue that you may have discussed elsewhere is absolutely valid and reasonable, and you have to engage. That said, we need to, if there are differences in the processes and then, of course, the outcomes, we want them to be explainable. Right, we need to understand where that has come from. Is it our fault? Have we engaged deeply with the UK regulator but given short shrift to the German regulator? Have we not made the efforts to ensure that there's a proper sharing of information? We've been transparent about the technical underpinnings of the decisions that we've taken. So there's something on us. There's, I think, a responsibility between agencies to be able to talk openly about how they have reached the conclusions they have reached. Privacy Sandbox has a good mechanism for that, which is regular reporting on how this process is going. I think the CMA has been very open. This is what we're saying to Google. This is the next step. This is the data we're relying on. This is what we've told them to do. So there's a lot of transparency there, which is very helpful for us because we can go to the other regulator and say, this is how this thing operates. So it's not something that troubles me per se. I think it's absolutely right and proper that we have to talk to different agencies and engage with different types of rules. I strive for there being, where there are differences, I don't want them to be something that I don't understand. I don't want them to be motivated by just a sort of different political environment, which doesn't seem always, that wouldn't seem like the fair outcome. But if we are looking at a different process, a different set of rules, different thresholds, different levels of understanding, well, that's understandable. And you have to do everything you can to affect the inputs that you control. That's how I think about that.
Yeah, I suppose a bit of a patchwork's inevitable in the end, in some ways. And if you look at, for example, Apple has been fighting lots of App Store cases around the world. There's the new App Stores legislation. It's not that new anymore. There's the App Stores legislation in Korea. So Apple made changes in Korea only. Then there was a judgment against Apple in the Netherlands. And so Apple made changes in the Netherlands only. So in a certain, so there's a choice there, isn't there, whether to go for a global solution or whether to look at it jurisdiction by jurisdiction. I mean, I think we'll find differing approaches by different companies and different regulators. So we're going to have to see how it plays out. But I suppose it's, this is the case in every, corporate law is different in different countries. Health and safety law is different in different countries. It was ever thus. It's just the amazing kind of efficiency efficiency of running a single global platform is something that has benefited the big tech firms and their users. But it's not. It's not always going to be set in stone that it's got to be exactly the same across the world, I suppose. Matthew, a couple of worries, if you like. What could possibly go wrong here? It's all very well intentioned, but there has been a bit of a debate about scope creep, as they call it. So everyone's been very worthy and said, this is only going to apply to a handful of firms, 4, possibly 5 firms, the obvious suspects. But that's not what the law says that's going through Parliament. The law gives the CMA the ability to designate anyone it can find as having strategic market status. And there is even a slightly bizarre report out by a think tank saying you could be regulating, I think, 500 firms. Are you going to regulate 500 firms, Matthew?
No, we are not going to regulate 500 firms. So first of all, in addition to those qualitative tests, don't forget the quantitative tests that I talked about. Now you're right. So you have to have £1 billion of UK turnover, or 25 billion globally. I'm sure that there are many in the audience who at least have those as aspirations, or maybe are there. But simply getting over that threshold is absolutely not going to mean that you're immediately or even likely to be in scope of what we're doing. I mean, even with the ramp up that I talked about, and I do think we need to put significant resources into building our capabilities, both in terms of people and data and knowledge and all the rest of it. Even with that, it is very clear, and I can be absolutely open about this, we will prioritize those areas where we think we can have the biggest impact for the biggest benefit to the UK consumers, to the economy, and to UK players in the ecosystems. And that is not going to be 500 firms or even anything in that region. So I really don't see that as a real possibility. I think as I said at the beginning, I think you've got to take the starting point is actually that this platform business model and these digital markets have delivered enormous benefits to UK businesses and to UK consumers. I mean, the UK is one of the most advanced, e-commerce economies in the world. I think we've got something like 129 or so unicorns in the UK. We want a thriving digital market. We are, but we do have certain characteristics of these markets. They have network effects, they have economies of scale, they have economies of scope, which mean that they can tip. And therefore, putting some rules of the road in place is not about kind of blanket trying to do that across huge numbers of things, but actually we think in a few specific areas, doing that will actually have two effects. It will give some certainty to the very large firms about their behavior, which is positive, frankly, because with the greatest respect, other than lawyers, I don't know anybody who really wants 10 years of litigation and then you win, lose or draw. It's kind of all a loss, frankly, because it's a huge amount of effort for the gatekeeper firms. It's a huge amount of effort also for the for the challenger firms and for the others who frankly could have been doing something else, could have been innovating, could have been building product, could have been building their brand and their engagement with consumers in the meantime. Bit of certainty is actually no bad thing, I think, for the whole ecosystem. And secondly, by doing this in a targeted way, I think we can still maintain, as much of the benefit, as much of the innovation, as much of the good stuff as possible, whilst dealing with some of these issues in a proportionate and targeted way. So that's what that's really what we're aiming for, and that's the mindset with which we enter into this process.
Thank you. I'll ask for questions, shall I, in a second, actually, if anyone's got any questions. So just maybe a final point from us. What does success look like here, Oliver? Or is there such a thing? Is it damage limitation?
In the UK or globally?
I'll leave it up to you.
I think Matthew puts it very nicely. I do think there's what sounds like a sort of pedestrian observation, but it's actually probably the top of my list, which is just a more effective use of our resources. And Matthew's quite right. There are lots and lots of questions coming into my team from the business And the more I can sort of narrow our focus on the things that are of real importance to Matthew and his team and organize my resources around that, the better. So I think there's that, a more efficient allocation of our resources, and also a sort of sense of predictability through the working week. Right? These are the things, and it's not going to be that we come in on a Monday morning and there happens to be a complaint that suddenly has pivoted us off into a new product area and a new type of concern, and we're all going to spend a lot of time on that. So I do think there is that efficiency benefit for us. I also think that with that more targeted type of dialogue with a regulator, you can move a lot faster in product launches. Yeah, I think that's absolutely the case. If I'm pulling people into sort of 10-year-long processes focusing on one particular concern and one particular search vertical, let's say, it slows down a whole raft of product launches that don't need to be affected by that uncertainty that now sits across Google's ability to integrate services, and a tremendous slowing down. Whereas on the other hand, if I'm having a very targeted and focused conversation with Matthew and his team about the nature of interoperability with Android and particular features where they have observed something that they would like to understand well, I can move forward in the other areas more quickly, and I think that's a tremendous benefit. And sort of circling back to the what's I think innovative and unique about the UK regime, which is that flexibility. I think the ability to very kind of much refine your course as you go will allow us to understand what are the non-designated activities. Yeah? Where are the areas where they aren't observing credible concerns for the moment, and I can advise my teams, listen, we can continue, let's be transparent and continue to be clear about what we're doing here, but this is a place where we can move as quickly as possible. We focus our efforts here. So I think it's that, really, a more efficient use of my resource, less expenditure on outside counsel, I suppose, as a part of that. But I think those are really the goals for us from this process.
Cool. Matthew, any final comment for you?
Just better working digital markets, really, at the end of the day. So I think if we're sitting up on a similar stage 10 years from now, I'd like to think that what we'll be saying is, right, we understand that. We're all clear about that. There will be new issues. There's just no question that there will be new issues. But we'll have some clarity in relation to areas where we've managed to, kind of really look at the data, look at the analysis, look at the way that that consumers are behaving, and get clarity over there, and then be quite specific and quite targeted about how we look at those new issues. And I completely agree that we're going to have to be data led on we need to be data led on these things. It needs to be based on facts and based on things that we can show, not based on just kind of a feeling that a certain firm may be too powerful in this or not powerful enough in that. That's not predictable, and that's not going to be the framework for something which is actually going to allow this part of our economy, which again, going back to the introduction to the whole day, is likely to be an area that becomes more and more important to our overall global competitiveness, and actually to improving the standards of living for citizens and for businesses and all the rest. And that's the end goal.
Lovely. Any questions?
We've got some questions from the chat online, so
great.
If I may, I'd just give you a chance to respond to them, and then obviously please in the room. So the first question was about how the panelists think the pace of innovation will be impacted by regulation. Do they perceive any slowdown in the pace of innovation? And the next question is perhaps the one we were all expecting, which is how does Gen AI, how has that changed the conversation for platform regulation, for big tech regulation in the last 12 months? Has the conversation changed? Thank you very much.
So I'll just say something briefly that on innovation. I mean, in the early years, there's just a lot of artificial restrictions, I would say, in the tech sector at the moment that can only really be holding innovation back. If you allow, which is now going to be allowed in the EU, and one would expect the CMA to have a similar rule, if you allow app developers to to avoid the App Store, for example, then they'll be free to avoid the Apple 30% commission, and can either offer their products for cheaper or make more money and invest it in innovation. Just freeing up app developers, for example. That's just an example, to communicate with their customers as well more freely, and to do what they want more freely. I mean, can only really help innovation. I don't know about, do you want to talk about Gen I and Bard?
Gen AI. So I think, what do I think about Gen AI? So look, just a quick observation. So I think the work of the regulator, the competition regulator right now, I think is the best version of that you see manifested with the CMA's work to sort of understand the underlying technology and how that might read across to competition theories of harm. I mean, I speak as someone who works within one of these companies and is exposed to a lot of the information around the product development. It is moving tremendously quickly. A lot of the sort of the ability to predict, even as an artificial intelligence expert within the company, is limited. And so I think that for the regulator to look at that and say, well, there's a project in education that we need to go through first is important. Now, it can't last forever, but that seems to be as a precondition requisite to sensible regulation in the space. I have, as an employee of a big search engine, I think one of the things that's interesting to me, and one of the things I think about and don't have a clear conclusion I can share with you today, but I think it's interesting, is how do you think about some of these technologies and their ability to provide overlapping functionalities, right? The ability to answer questions and examine the computational theories that might emerge from that, while also being cognizant of the priors that you're going to bring to that analysis. Is the fact that someone who's very successful in traditional online search, does that naturally mean that when it comes to information retrieval via one of these agents, that the same things that I understood there apply in the same ways? Access to a large amount of data. Can I just port what I thought about data aggregation theories of harm in an online search environment to Gen AI agents? I think probably not perfectly at least. So I think there are some interesting kind of questions there, and I'm very encouraged by what I've seen in the CMA's initial study, and that's just the beginning of this, right? There'll be another report coming. But there I think it's very much a sort of a humility that I share myself in looking at how these systems work. What is the mathematical underpinning of the way in which Palm 2 is creating the model and all of those kinds of things, which allow you to sort of come at this afresh and say, well, actually, maybe those data aggregation theories don't hold in the same way. And just to finish with a little sort of nod back to the Digital Markets Act, what the Digital Markets Act does, prospectively looking ahead, is in a particular provision says, well, what we need to do to address search competition is to provide access to search queries and click data. And I look at a provision like that and think, well, okay, how fit for purpose will that be when I think about the new variance on competition in information retrieval? So I think that's all I'll say on that. That's an area that I'm paying particular attention to.
Yeah.
We're probably over time, aren't we? But maybe do you have any burning point to make?
I think that's
great. So I've run over, so I've totally failed. Sorry. But thank you very much, everyone. Thank you.